Good day, Crime Talk aficionados. It is Sunday, which means it is time for the weekly recap for the week of February 10th, 2025. That's right. All of the top stories, all of the top discussions located in one convenient location right here. Enjoy. And remember, the Constitution matters.
All right, lawyer.
And first on the docket, Luigi Mangione. That's right. The young 26-year-old charged with the murder of the United Healthcare CEO, Bryan Thompson. Guess what? He has accepted $292,000 that have been raised towards his legal defense fund, and he says, thank you. Now, Mangione is accused of killing Thompson outside of a Manhattan hotel on December 4th of 2024, and he faces obviously criminal charges, both in New York, Pennsylvania, as well in federal court in New York. Now, this guy who went to Ivy League schools, has graduated from Ivy League schools, smart guy, has pled not guilty to the New York State charges and has not yet made pleas in the federal venue, and he hasn't even been back to Pennsylvania since he was extradited to New York. So the December 4 Legal Committee, which was created, a Give, Send, Go legal fund, announced today that Mangione would be accepting the more than $292,000 in funds that the group has raised on his behalf for his legal defense fund. And the group says, quote, "We're thrilled that Luigi is accepting these funds so that he can mount the strongest defense possible," said D4 Legal Committee spokesperson Sam Beard in a statement. "The American private health insurance industry has ruined countless lives by denying people access to basic care and burying families in medical debt." Anyway, this announcement comes a week after Mangione's lawyers told the press that her clients planned on using the donations, because nothing better for a good defense than a good pot of money where you can leave no stone unturned, hire as many experts as you need. It's the best thing. I'm just telling you as a lawyer, when somebody says, I don't care what it costs, and they actually mean it, and they prove it, and they back it up, usually you get good results. So who knows what's going to happen to Luigi? We make no promises, but money does matter in the legal system, ladies and gentlemen. Depends on the type of lawyer that you can afford to get. Obviously, their skill, their experience, and the resources that come with it. Experts, investigators, psychologists, psychiatrists, any kind of expert you can possibly imagine. It is all funded by money. So apparently, the attorneys for Luigi have said that he is aware of the fund and very much appreciates the outpouring of support. The attorneys say that Luigi plans on utilizing it to fight all three of the unprecedented cases against him. And at the time, like I said, the December 4 Legal Committee had $240,000 in contributions. Like I said, it's closer to $292 now. Anyway, the group says that it will continue to raise money for Mangione for the duration of the trial, and we encourage, the group does, not we, Crime Talk, the group does, encourages millions of supporters to find creative and public ways to advocate for Mr. Mangione during his time behind bars, including donating and sending him mail. He loves to receive letters, memes, and books. The December 4th Legal Committee also put out in a statement. Now, for those, like I said, need a little more background, Mangione was arrested on December 10th at a McDonald's in Altoona, Pennsylvania, following a dramatic 6-day manhunt that drew nationwide attention. And in Pennsylvania, he faces the least severe charges of carrying a gun without a license, forgery, and a sundry of a few other miscellaneous counts. He was then extradited to New York on December 19th after waiving his rights to an extradition hearing, which is not a big deal, not surprising. And he is next scheduled to appear in New York State Court on February 21st. There he faces 11 charges, including murder in the first degree, murder in furtherance of terrorism, second-degree murder in furtherance of terrorism, and multiple weapons offenses. At the federal level, he's charged with murder through the use of a firearm, 2 counts of stalking, 1 firearm offense, and if he's convicted, the count of murder through the use of a firearm carries the possibility of a death penalty. Now, it's not immediately clear if the prosecutor intends to seek the death penalty. However, in light of the new Justice Department head and a memo that went out basically saying that particularly if it relates to the death of a police officer. The Department of Justice expects all of the attorneys, the U.S. attorneys, to go after the death penalty. All right, good luck, Luigi. You got money. I'm sure there's more where that came from. Keep sending it, ladies and gentlemen. We want a great trial. Hopefully they'll televise it, but I don't think New York does that, and I know the feds don't do it. And yes, the Karen Read case. I get it. We're giving Karen Read the presumption of innocence, and I probably would have voted not guilty based upon the original trial. But I've said all along that her idea that somehow she was entitled to this not guilty verdict on the counts that were never recorded in open court, I didn't think she was going to prevail. And guess what? I was right. Not trying to say I told you so, but just trying to be realistic here. When the court did not take the not guilties in open court, jeopardy had not attached. And to say otherwise, I think, is a little intellectually dishonest. In this particular case, Miss Reed wanted her cake and eat it too, which was declare a mistrial, judge, declare a mistrial. And the jury in this particular case somewhat misled everybody by saying they were deadlocked on all. It made it sound like on all counts. What did you expect? Anyway. So Karen Read is going to face all of the same charges, including the second-degree murder, when she stands trial for the second time this spring after the Massachusetts Supreme Court, the highest court, denied her bid to toss those charges. Now, for those who aren't familiar with the case, prosecutors have accused Miss Read of running down her boyfriend, now former police officer John O'Keefe, with her SUV and leaving him to die in the cold and snow outside of a friend's home. Now, Miss Read has maintained her innocence, and her defense has alleged a wide-ranging cover-up at the hands of the investigators and the owners of the home where O'Keefe's body was ultimately found in the morning. Now, Read's first trial ended in a mistrial after jurors reported they were hopelessly deadlocked. And in the days after the trial, Read's defense attorney filed a motion saying that jurors had contacted them to say no. In fact, they had been unanimous that Read had been not guilty on the second-degree murder, and the panel was only split on the lesser charges. So, in their appearance before the Massachusetts High Court, Read's attorneys argued that retrying Read on the murder charges would amount to double jeopardy. Her defense attorney said they were contacted by 5 jurors after the trial and argued that the affidavit from the jurors reflect a clear and unambiguous decision that Miss Read is not guilty on those charges. Now, prosecutors argued that the jury's notes stated that it was deadlocked 3 times and never indicated that it had reached a unanimous ruling on any charge. And guess what? The prosecutor, the defense attorney, nor the judge ever asked if they had reached a decision on any of the charges. So the Commonwealth conceded that it too had been contacted by jurors who said that the jury had voted not guilty on at least one count. But in its decision, the Supreme Court found that there was no abuse of discretion of Judge Cannon's decision to declare a mistrial. The court also found that the jury's third and final note implied that they were deadlocked on all of the charges, not just some. Gee, if we go back and look at those videos that Scott put up, I know it's going to be that this is what I said. Vindicated. And like I said, I would have voted her not guilty after the first trial. It was a complete screw up on the prosecution's part. And now they're going to come back and they're going to fix the charges. They're going to fix the trial. They got an experienced prosecutor this time. Look out. Anyway, that note, the one that said we're deadlocked, it reads as follows. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. Now, the justices also found that had Judge Cannon inquired whether the jury had reached a partial verdict, Read would have standing to argue that any verdict was the result of some sort of coercive intrusion on the jury's abilities to do their job. But they didn't. Anyway, retrial is set to begin on April 1st. Her attorneys have indicated that they plan to file another motion to dismiss the case in its entirety, and a hearing on that motion is scheduled for March based upon discovery violations. That probably has more play than this argument did, whether it was in the trial court or in the Supreme Court, obviously, because they said no. Somebody the prosecutors, the defense attorneys, or the judge could have asked, have you reached a decision on any count so that we can take a verdict on those? But they didn't. And so since they all failed to do it, basically the court says, a pox on all your houses, go do the trial again. The Bryan Kohberger case. All right. Been a lot of talk all of a sudden about some statements that were made in the motions hearing as it relates to Bryan Kohberger last week. There's a couple of pending motions that are causing a big brouhaha. We've talked about the motions. Most of the pending motions that have not been resolved relate to the affidavit that the police submitted to basically arrest Bryan Kohberger, as well as that information that led to all types of other evidence that led to Bryan Kohberger. Needless to say, we've talked about this, and you're getting this from somebody who's practiced criminal defense for 3 decades now, is that you want those things to go away. That's the crux of the case. So let's kind of lay the groundwork here. We'll find out, we'll frame the issues, what the issues are, and we'll see if Bryan Kohberger is going to be exonerated or if this unidentified blood DNA of 2 other individuals exonerates Bryan Kohberger, or does it just simply say he had co-conspirators? Let's talk about it. So, detectives who investigated the Moscow College student homicide found blood at the crime scene from still 2 unidentified males. Now, attorneys for Bryan Kohberger revealed at a recent hearing, hinting to a possible legal defense strategy at trial. Now, an unknown individual's blood DNA was discovered on a handrail in the off-campus home where the 4 University of Idaho students were fatally stabbed. Another unknown blood sample was found on a glove that police located just outside of the home. Now, like I said, this was in the hearing that we brought to you. We can put a link to that, so if you want to watch it for yourself, all right? Now, in the bed of one of the stabbing victims, police say they also found what many regard as the case's key piece of evidence, which I believe is the key piece of evidence. It is a leather knife sheath from a K-bar, right? And during the processing, DNA was discovered on the sheath and later matched directly to Bryan Kohberger. That's right, here on this little button right here. Okay, this is my own personal K-bar. Had it since 1988 when I went to boot camp. What other show has their own K-bar? Not a single one. Anyway, that DNA matched directly to Kohberger, and police and prosecutors, that's what they're alleging in their filings. Now, in the legal filings from the June 2023, defense attorneys said the state's claim is not from blood, but rather from touch DNA on the sheath located at the scene. Now, in those same filings, the defense said DNA from 2 additional males was found inside the home, and the male DNA was found on the glove outside. Now, the prosecutors have stated to the court at that hearing in August of 2023 that those DNA samples were not uploaded to try to identify them through the FBI's National DNA Database, known as CODIS, because they apparently were not eligible based upon the criteria. Normally what that means is they were maybe not able to get enough of the unidentified male DNA, enough loci for the samples to be sufficient enough to go into CODIS. I see that quite often where they'll have unidentified, say they only get 3 loci of maybe the 17 that they tested, and therefore it's not sufficient to be uploaded into that database. And once again, even if there was blood there, it could have been from nights before. Who knows how somebody could have been there, had a party, cut their finger, opening a beer top. Who knows? But it's there. The defense is going to try to make some hay out of it. Now, it was not publicly known until last month's court hearing that at least 2 of the unknown male DNA samples came from blood. Now, the type of the 3rd male DNA sample remains unclear, as is whether its source has been identified, but police did not disclose this unidentified DNA sample to the magistrate judge back in December of 2022 when they sought a warrant for Bryan Kohberger's arrest. Now, the defense attorneys alleged at the motions hearing that the prosecutors did not dispute that it didn't go into the affidavit, and the decision amounted to detectives intentionally omitting the information to the judge for her determination of probable cause, and then should disqualify some of that evidence, is what she's trying to say. She's saying, you didn't tell them everything. Therefore, it's not a valid search, and we want some remedy for that. We'll discuss that more when we get to the Franks issue. All right. Now, in the bed of one of the stabbing victims, police said that they also found what many regard as the case's key piece of evidence, the leather knife sheath, right? Or obviously the blade that was not found and never been found. Now, during the processing, DNA was discovered on the sheath and later matched directly to Bryan Kohberger. So the defense is arguing that the decision to intentionally leave out the source of these two other unidentified blood DNA samples was intentional, and they intentionally omitted that information to the judge for her determination to probable cause, and therefore they want to disqualify some of that evidence, according to the defense argument. Now, the unknown male blood DNA samples police found inside and just outside the King Road home raise important questions about the investigation, the defense is arguing. And Ms. Taylor, Bryan Kohberger's attorneys, said that the evidence, which she argues is material and exculpatory, meaning it supports Bryan Kohberger's claim of innocence, and that was directly kept from the judge ahead of their client's arrest. Now, the information is not necessarily exculpatory for Mr. Kohberger, the judge noted to her. Rather, it could suggest the possibility that other suspects were involved. If you assume that the blood was related to the victims and not some earlier event in the house, the judge noted, regardless of if the defense prevails in convincing the judge to grant a Franks hearing or to suppress other states' evidence, it's likely that Kohberger's attorneys will use the unidentified blood DNA from the crime scene to try to, create reasonable doubt at trial. The primary challenge for the defense in Kohberger's capital murder case here will be explaining to the jurors why the knife sheath just happened to have his DNA on it and just happened to be at the scene underneath one of the victims that the defense notes that they had no relationship to the victims in any way. Some people say it could have got there by anybody. It could have been planted, but how would they have known to plant it for Bryan Kohberger's DNA if they didn't even know who he was at the time? And why would they plant it? And obviously, that's the thing that squarely puts Bryan Kohberger at the scene. The magnitude of that evidence to the state's case is obviously critical. And, well, we can't understate it at all. That is their case, ladies and gentlemen. If that goes away, there is no case against Bryan Kohberger. Now, Kohberger's defense team has said on several occasions that he is innocent of the crimes for which he is accused. And Ms. Taylor, his lead attorney, reiterated that at last month's hearing, that no connection exists between her client and the victims. In spite of these allegations, Bryan Kohberger has never been to the King Road home, she said, and police executed a search warrant at Kohberger's apartment and sought a variety of evidence. That included all DNA evidence, which entailed any items with blood, bloody fluids, human tissue, skin, and cells. Initial analysis from the presumptive chemical tests on the stained mattress cover and pillow taken from Bryan Kohberger's apartment came back positive for blood, according to police records. We're assuming it's his blood because we have no reason to believe it's anybody else's blood at this point. Next, the King Road residence contained a significant amount of blood from the victims, including splatter and cast-off bloodstain patterns and from blood drops released from an object due to its motion, which is based on the officer's training writing the warrant. That's why he put this particular language in the warrant, which makes it likely that this blood evidence was transferred to Bryan Kohberger's person, clothing, or shoes. The Moscow Police Department wrote in their affidavit for the search warrants. But none of what was seized related to the four victims, according to his attorneys. During the search of their client's apartment, in addition to 3 searches of the white Hyundai Elantra, police found absolutely no connection between him and anybody from the 1122 King Street address. There's no blood in his car, his attorneys noted. He wasn't connected to the house, to the people in the house, and during the court-approved search, his attorneys note, police pulled the apartment apart. They took apart components, including the brake, the gear shift, and key fob remote of Kohberger's car. Nothing tying Kohberger to the victims was found in the steering wheel either. one of the victims in the stabbing, Kaylee Gonzalez, owned a dog with her ex-boyfriend, and the police found it in her third floor bedroom when they arrived at the crime scene. Now, according to the probable cause affidavit. Now, the door to her bedroom was opened and was Mogan's third floor bedroom where Gonzalez and Mogan were found deceased. Now, Taylor told the court at the hearing this dog had not tracked any blood around, she said. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later. Now, police suspected Kohberger returned to his apartment after this violent knife attack, hoping that they would find something. But as we know, as of right now, there is nothing. So at that time, it is likely that he still had blood or other trace evidence on his person, clothes, shoes, including skin cells or hair from the victim's dog, the officers wrote in their affidavit. And it is likely that some trace evidence was transferred to areas in the apartment through contact with the items worn during the attack. Once again, per the search warrant. Now, a search warrant return showed that 24 items, including at least 10 possible hair strands, one that was possibly from an animal, and 3 more possible hairs among all that police seized from Bryan Kohberger's apartment. Now, on a list of more than 50 exhibits the defense team submitted to the court in support of its Franks hearing, they included 2 FBI lab reports for hair fibers, each noting no connection. It is unclear if the 2 FBI reports the defense submitted relate to the possible hairs police located during the search of Kohberger's apartment. Anyway, the judge told the defense for Bryan Kohberger last month that a direct DNA comparison between the defendant and the knife sheath at the location of the quadruple homicide would seem to close the book on the matter of probable cause. The question jurors will have to weigh for a possible conviction is the proof beyond a reasonable doubt standard, the judge noted. There may be, as you say, other people that created concern or issues that need to be investigated, the judge noted, but I'm not sure that diminishes the probable cause of Mr. Kohberger if his DNA is found on that knife sheath found on or near the victim, who was stabbed with said alleged knife, would have been in the alleged sheath, the judge also noted. And let's not forget, how did a sheath for a fixed blade knife get there? And how did Bryan Kohberger's skin cell allegedly wind up on it if he was not involved? Well, the defense team acknowledged that this is the most significant issue ahead of the trial. I mean, that's the ultimate question that will be before the jury. Bryan Kohberger's attorneys argued, what does a knife sheath at the scene mean? Hippler shot back, if you're killed with a knife, that probably means a lot. Ms. Taylor responded, it might. So here's the issues, ladies and gentlemen. First, should the judge grant a Franks hearing? I don't think that he will. Now remember, a Franks hearing is based upon a federal case, Delaware v. Franks, where it states that police have to put in, obviously, the relevant facts to get a search warrant or an arrest warrant, but they also have to include exculpatory evidence. But they don't have to list every single piece of evidence that they find. Now, obviously, if there's some exculpatory evidence, then that would be something, if it was potentially excluded, that the judge would have to consider. However, when you're getting an affidavit for one particular person, the police may be thinking there are other suspects here. We have this unidentified blood. There isn't a sufficient sample, but that doesn't mean that you can't find probable cause for Bryan Kohberger. Now, does it mean just because they found probable cause that he'll be convicted? No. The government has a heavy burden to prove at trial, proof beyond a reasonable doubt, which is the highest form of proof known in the law, not just here in the United States, but anywhere else in the world. It is not a vague, imaginary, or a speculative doubt, but a doubt that would cause peoples to pause in matters of great importance to themselves. All right? So, do I think the judge is going to grant that Franks hearing to say that the detectives left something out? No. Even if the judge were to say they should have probably included it, but it doesn't mean that the magistrate judge would not have found probable cause to go and arrest Bryan Kohberger. It doesn't mean that all of the other warrants that they sought from Google and Amazon and his phone records, that somehow nullifies all of that. I don't see Judge Hippler making that leap. He is correct. Just because there's other blood DNA, they don't know who it is, they can't make out a sufficient sample, doesn't mean Bryan Kohberger wasn't there. All that means is there may have been other people involved, assuming you could say that blood was there at the time of the murders. And if you can't say that, then it's just speculation. All right. So is it going to get thrown out on a Franks issue? No, I don't believe it will. The issue here is the court finds probable cause, and the issue is framed exactly as the court noted. Will the prosecution be able to prove their case beyond a reasonable doubt that Bryan Kohberger caused the death of these 4 young college students on the date and place charged? And that's it. And this is where people get hung up. They always think that there's going to be some silver bullet that's going to make the case go away. And it's not. Everything for warrants is a probable cause standard. Would a reasonable person believe that a crime was committed? Well, obviously there was a crime committed. There were 4 dead people there, right? Would a reasonable person believe that Bryan Kohberger may have had something to do with it? May have had something to do with it, ladies and gentlemen. When your touch DNA, right? Your touch DNA just happens to be on the knife sheath underneath a victim at a crime scene, and you could say they were stabbed, I think that is probable cause. So this case is not going to get dismissed by the judge. My mouth would drop to the floor if that happened. I don't see it happening. This is a question of fact for the jury to decide. And like I said, a lot of people think, oh, there's going to be some great motion, it's going to be dismissed. Bryan Kohberger's innocent. There's not. Probable cause is such a low standard. He could have had his, preliminary hearing. He continued it. He got indicted. They've already established probable cause. That's it. Okay. The genetic genealogy stuff, the court is going to rule against the defense in that as well. Yes, it sounds like the FBI violated their own protocol to go to these DNA websites in search of this DNA profile that ultimately connected Bryan Kohberger's father to get it to go back to Bryan Kohberger. They violated their policies. Okay, that's certainly ripe for cross-examination. And I'm sure the agents will say, yes, we have policies, but sometimes, like all good rules, are meant to be broken because we were trying to solve the homicide of 4 young people, and we want to bring justice to them. So yes, we made the call to go against that. It's a policy. It's a guideline. It's not written in stone. We didn't violate any law. So genetic genealogy staying in, and I don't think we're going to get a Franks hearing. Now, like I said, I'm a criminal defense attorney. I'm always rooting for the defense, but sometimes you can't avoid reality. And if you go back and you look at all of my shows, I've said the biggest issue, and the judge knows it, the prosecution knows it, and the defense attorneys know it. It all comes down to this little knife sheath. If there's like an Amazon delivery for a United States Marine Corps K-bar, that's a problem for Bryan Kohberger. My guess is that's why they're trying to suppress those Amazon records. But hey, we haven't seen that, but I'm just taking a wild guess. Because remember, ladies and gentlemen, they suppress the evidence that the defense deems bad for them. And that's why they want it to all go away. Ultimately, it's going to come down to a question of fact for the jury to decide. Next, remember the Sidney Powell case? The one that got reversed because the judge didn't allow them to present SIR rebuttal? Got reversed? Well, prosecutors in Ohio are asking the Ohio Supreme Court to intervene as they fight to have Sidney Powell's murder conviction reinstated. Now, Ms. Powell is currently serving a sentence of 15 years to life for murdering her mother, Brenda Powell, back in 2020. At her murder trial in 2023, Sidney pled not guilty by reason of insanity and presented testimony from several doctors who said she suffered from multiple mental illnesses, including schizophrenia disorder. Then in December, Ohio's 9th District Court of Appeals granted Sidney's motion for a new trial, finding that the trial judge erred by not allowing her defense to present a SIR rebuttal. And in their motion arguing for Sidney's conviction to be reinstated, prosecutors said that the 9th Circuit District Court broke with more than a century of precedent and issued inaccurate guidance to trial courts, suggesting that criminal defendants have an unconditional right to present SIR rebuttal evidence whenever they assert an affirmative defense. Anyway, the prosecutors representing the state of Ohio in the appeal warned that the appellate decision could have a statewide impact, and the 9th District erroneously made a decision not only undoes the deliberative work of these jurors, but also has the potential to serve as a vehicle to entirely rewrite the order of trials throughout the state of Ohio. In sum, the prosecutors say the 9th District's decision contravenes more than a century of authority, will lead trial courts astray and transform trials into an endless sequence of rebuttal and sur-rebuttal. Now, Powell's insanity defense, which is considered an affirmative defense, which says, I did it, but I have a good defense, in this case, not guilty by reason of insanity. And under Ohio law, Cindy's defense argued in its appeal for a new trial that the sur-rebuttal was, in fact, a rebuttal case for the defense case in chief. No hearing date has been set for the appeal, and Cindy's defense has not yet filed a response. So remember, ladies and gentlemen, prosecution presents their case in chief. The defense, although never has to present a defense, can. And if they do, they can call witnesses. The prosecution then usually gets to present rebuttal, but it's usually very specific. Oh, somebody said the light was green. Well, we have a witness that says the light was red. Just giving a simple example. Then that's usually where it ends. But it has to be very specific. You don't get to retry your whole case all over again. And so the defense would then say, well, we have another witness that will testify that the light was the color that we thought it was. They should have been cut off at that point because, one, they had their opportunity to present their case in chief, and it would be cumulative at that particular point. And what point is it rebutting? So they go back and forth. Well, we got another witness. No, you only get one bite of it. So understand it's a weird ruling. It's involving a young, defendant, mental health issues. Maybe the Court of Appeals was trying to help somebody out. Sometimes you see that in unpublished opinions that have no precedental effect. But in this particular case, it's going to be interesting to see if the Ohio Supreme Court takes the case on cert, or they say, no, we'll let it stand. And hey, judges, don't get carried away on granting rebuttal and sur-rebuttal testimony.